According to the Washington Post, a record 7 million Americans are 3 months before on their auto payments February 2019. That title says it all. In other words, if you're filing ruin and have missed your auto payments, but you still want to keep your auto, you aren't alone. The Credit Union Journal has a recent composition in the May 2019 edition named, "In Avoiding Subprime Bus Loans, Are Credit Unions Shuffling Their Roots?" It turns out that auto loan defaults are formally again at major highs. This is a civil problem for lenders, and not just locally then in Ventura County or Los Angeles County. There are legal remedies you can in place to stop your auto from being repossessed. Numerous consumers don't realize that under both Chapter 7 and Chapter 13 bankruptcy law you can temporarily help auto reclamation by your lender. This is because during ruin proceedings the court issues an automatic stay prescribing and precluding the lender from reacquiring your auto. The lender can ask the court remove the automatic stay, and if the court agrees, the lender may take possession of the auto anyway, but this temporary stay may be all you need to get the lender's attention to work with you and your attorney on a modified prepayment plan. The stylish way to deal with this situation is to be in contact with your auto lender, and it's stylish to do that through a ruin attorney. It holds further weight. It also stops the lender from trying to bully you. Your attorney can talk the terms and help you set up a new payment structure, therefore, allowing you to keep your machine in a ruin. Consider if you feel that lenders do not really want to reclaim buses. They aren't in the automotive business, they're in the lending business. They just want to be paid, as per the original agreement. However, they will weigh their options and consider what is stylish for them. If they realize that is not going to be, maybe, a reduced interest rate, reduced balance, or reason terms are better for the lender than a repossessed habituated auto with low resale request value due to wear and gash and depreciation. Face it, lenders don't want to lose any further plutocrat than they absolutely have to. Another important point you must remember, the automatic ruin stay is only temporary, and if you have not been making timely payments, once your case is closed you can anticipate the lender to demand return of the auto or they will reclaim it. Also keep in mind that the stay is only good during the ruin proceedings, which for Chapter 7 lasts about 3 months or so. What is the stylish way to help auto reclamation during bankruptcy court proceedings? Make the payments. Make up missed payment. Come up with a prepayment plan. Ask court to authorize it. Stay in contact with the lender through your attorney. Ask for some help, maybe paying interest only for a couple of payments. Talk the auto loan. Ask court if you can buy your auto back for its fair request value, redeeming your auto under Chapter 7 bankruptcy law. Ask your ruin attorney about gram down strategies in Chapter 13 ruin. What can you do if your auto is repossessed before the bankruptcy filing date? Ask your ruin attorney to help you come up with a prepayment plan so the lender can get the missed payments. However, and if your auto has formally been repossessed, don't delay. If this has happened to you, call your ruin attorney now. That is presumably the stylish advice of all. Casting it all up. You need to know your rights and understand the provocations of your lender. You need a good solid ruin counsel who works for you, one who has dealt with the original lenders then in Ventura and LA County. An attorney who gets it and has decades of experience. With the right strategy, you will be suitable to keep your auto, help demotion, and help loss of your transportation. After all, we live in California and you need the auto.